The Law of Self-Defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Hey folks, welcome to our ongoing Law of Self-Defense coverage of the criminal trial of Kyle Rittenhouse. Before I dive in, I'd like to express my tremendous appreciation for the gracious sponsorship of CCW Safe, which makes it possible for me to share my coverage and analysis of this trial with all of you on an open access basis. For those who may not know, CCW Safe is a provider of legal service memberships, what many people mistakenly call self-defense insurance. They, in effect, promise to pay their members' legal expenses if the members involved in a use of force event. Of the various companies offering this kind of service out there, I find CCW Safe to be by far the best fit for me. I'm personally a member. My wife, Emily, is personally a member. Whether they're the best fit for you is something only you can decide, but I do encourage you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCWSafe. And if you do decide to become a member there, you can save 10% off your CCW Safe membership by using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10 at that URL, lawofselfdefense.com/CCWSafe. Now, as all of you know, Kyle Rittenhouse has been charged with a number of crimes for his conduct in Kenosha, Wisconsin on the night of August 25th, 2020, amidst violent rioting in the city, fomented by elements of Antifa, Black Lives Matter, and sympathizers of those groups. Most of the charges against Rittenhouse are serious felonies, including the charge of first-degree reckless homicide for the killing of Joseph Rosenbaum, first-degree intentional homicide for the killing of Anthony Huber, attempted first-degree homicide of Gage Grosskreutz, and 2 counts of first-degree reckless endangerment. The intentional homicide charge carries a sentence of life in prison. The attempted first-degree intentional homicide charge and the reckless homicide charge carry a sentence each of 60 years in prison, and the reckless endangerment charges carry a sentence each of 12 years in prison, and all these sentences would be supplemented by an additional 5 years because of the gun sentencing enhancement. Then we have this odd little outlier gun charge, possession of a dangerous weapon by a person under 18, per Wisconsin statute 948.60, which is, of course, linked in the text version of today's content. This is a Class A misdemeanor under Wisconsin law, punishable by up to 9 months in jail and a fine of up to $10,000. If this were the only charge on which Rittenhouse were convicted, and given that he has no prior criminal history, he may well face no jail time whatever and only a relatively modest fine, even if convicted. And the bringing of this relatively modest charge raises a couple of interesting questions. The first question is, upon close examination, does it appear that evidence exists to even support probable cause to believe that Kyle Rittenhouse even violated this gun law at all? More specifically, the defense here is arguing that a plain English reading of the statute rather obviously excludes the conduct of Rittenhouse on the night of August 25th, 2020. Accordingly, the defense has filed a motion with Judge Schroeder, the trial judge in this case, to have this particular misdemeanor charge dismissed. And the arguments made on October 5th, 2021 at a pretrial hearing around this motion are what we're covering in today's content. In response to the defense argument for dismissal of this misdemeanor gun charge, the state argues that the court should read beyond the plain English of the statute and apply a less concrete interpretation of legislative intent to find that the statute is, despite the plain English reading, applicable to defendant Rittenhouse. So I mentioned there's a couple of questions raised by this whole gun misdemeanor charge. The first question is, does the charge even apply to Rittenhouse as a matter of law? The second question is, even if a rational argument exists for finding Rittenhouse criminally liable under this statute, why is the prosecution pursuing this mere misdemeanor gun charge when it's already charged Rittenhouse with no fewer than 5 serious felonies, 3 of which would put Rittenhouse in prison for much of, or for the entirety of the remainder of his life if he's convicted? More specifically, does the prosecution simply have such a lack of confidence in the felony charges that it's throwing in this misdemeanor as a safety charge to try to ensure at least some level of conviction for Rittenhouse? Or might there be a more clever or arguably more sinister motive to the inclusion and the rigorous defense of this charge by the prosecution by the state here? So let's address each of those questions in turn, beginning, of course, with the first question. But given how lengthy this analysis has turned out, we'll be dealing with it as a two-parter in terms of content. So with each part dealing with one of the two key questions, what we'll address here in part one is the question of, is the gun charge at all applicable to Rittenhouse in the first place? And then in the subsequent part two, which I'll try to link to here using YouTube cards, but I confess my YouTube foo is very limited. But the part two will also be in our YouTube channel. And then ask the question, why is the prosecution pursuing this mere misdemeanor gun charge just as a safety charge, just in case they can't get the felony convictions because they don't have confidence they can get the felony convictions? Or is this a more sinister backdoor attack on Kyle Rittenhouse's fundamental claim of self-defense in the first place? So, starting with the first question, is the gun charge at all applicable to Rittenhouse in the first place, given the facts of this case? And perhaps the single greatest complication in understanding whether this gun charge under Wisconsin Statute 948.60 is at all applicable to Rittenhouse in the first place is that the statute itself is full of various conditions and exceptions that go on to reference other statutes that themselves are full of various conditions and exceptions. One important provision of 94860 reads as follows, and this is subparagraph 2A. Any person under 18 years of age who possesses or goes armed with a deadly weapon is guilty of a Class A misdemeanor. Well, Kyle Rittenhouse was only 17 years of age at the time of these events, so on that basis, he certainly seems to meet the under 18 criteria of 948.60. He was also certainly in possession of a deadly weapon in the form of an AR rifle, as learned so fatally by Joseph Rosenbaum, a reported child molester, and Anthony Huber, a reported domestic abuser, and with maiming consequence by Gage Grosskreutz, a reported weapons criminal, when they made the ill-informed decision to attack an armed Kyle Rittenhouse. So does all that mean that Kyle Rittenhouse was committing a Class A misdemeanor under Statute 948.60? Well, maybe if those were the only conditions of Statute 948.60 that must be met in order to have committed the specified Class A misdemeanor, but they are not the only conditions of Statute 948.60, which is why it's always important, especially in the context of statutory interpretation or statutory construction, to read the whole thing. That's why we link these statutes in the text version of our content. Other provisions of 948.60 relevant to the facts of Kyle's possession of the rifle can be found in paragraph 3C of that statute, which reads in relevant part, quote, "This section applies only to a person under 18 years of age who possesses or is armed with a rifle or shotgun if the person is also in violation of a separate statute, 941.28, or is not in compliance with two other statutes, 29.304 and 29.593. All of those statutes, of course, are linked in the text version of this content. Okay, so what that tells us is that even if a person under 18 years of age triggers the conditions of paragraph 2A of the gun law, 948.60, they've still not committed a violation of that statute unless they also trigger the conditions of paragraph 3C by either violating 941.28, which pertains to short-barreled rifles, or they are not in compliance with either 29.304 or 29.593, which both pertain to hunting use of firearms. Well, was Rittenhouse in violation of 941.28, the short-barreled rifle statute, or was he not in compliance with 29.304 or 29.593, the hunting provisions? If the answer is yes to any of those, well, then Rittenhouse appears liable to misdemeanor conviction under 948.60, the gun charge. But if the answer is no, for all of those, then Rittenhouse appears not subject to 94860, the gun charge, at all. So let's take a look at the first of those subsidiary statutes, the short-barreled rifle statute 941.28. So in summary, for our purposes here, 941.28, paragraph 2 makes it a felony for anyone to possess a short-barreled rifle, which the statute defines in its first paragraph as a rifle having one or more barrels having a length of less than 16 inches, measured from closed breech or bolt face to muzzle, or a rifle having an overall length of less than 26 inches. So that's the short-barreled rifle statute in Wisconsin. And if the rifle possessed by Kyle Rittenhouse meets that definition, then he's also violated the misdemeanor gun law he's charged with. By the way, if that was true, he'd also be charged with the felony short-barreled rifle law, right? Which he's not. And in part, that's because in this case, not even the prosecution is arguing that the AR rifle possessed by Rittenhouse qualifies as a short-barreled rifle. So Rittenhouse cannot be liable for the misdemeanor gun charge based on this provision of 941.28 that he was actually in possession of a short-barreled rifle. He was not. So that's off the table. That leaves the possibility that Rittenhouse could be convicted of the misdemeanor gun charge if he was not in compliance with the hunting and use of firearms provisions of 29304 or 25.593. So let's consider the first of those, hunting and use of firearms provisions. 29304, restrictions on hunting and use of firearms by persons under 16 years of age. So if Rittenhouse is not in compliance with this statute, well, then he's also not in compliance with the misdemeanor gun charge law against him. Now, the subsections of this statute, 29304, place various degrees of restriction on hunting and the use of firearms by persons who are under 12 years of age, who are between 12 and 14 years of age, and who are between 14 and 16 years of age, respectively. The question then is, was Rittenhouse not in compliance with this statute, 29304? And the defense argument presented by defense attorney Chirafisi is straightforward and based on a plain English reading of the statute 29304. The statute applies only to persons under 16 years of age. And Rittenhouse was 17 years of age on the night of the events of August 25th, 2020. In short, then, the defense argues Rittenhouse cannot be not in compliance with 29304 because, by definition, 29304 simply does not apply to 17-year-olds at all. Now, Judge Schroeder, without prompting by the prosecution, expressed objections to this interpretation, or at least hesitation about it, of Statute 29304 in terms of a concern that lawyers call the exception swallowing the rule. So a basic presumption of statutory interpretation is that the legislature must have had some rational purpose in creating the statute in the first place. If a plain English reading of the statute results, apparently irrationally, in the statute having no effect, then it falls to the court to read past the plain English reading of the statute to attempt to discern some rational legislative intent behind the statute. Now, a simple example of this kind of irrational statute that provides that the exception has swallowed the rule might be a statute that reads, no one may ride a bicycle over 100 miles an hour within the city limits, and then has an exception that says, this provision shall not apply within the city limits. Well, when one applies that exception, there's nothing left of the rule. The exception has swallowed the rule. A plain English reading of this hypothetical statute makes it pointless. But surely a rational legislator had some intent behind the statute, and ought the court not read past the plain English reading, which is irrational, to try to discern that legislative intent. In the case of Rittenhouse, Judge Schroeder is apparently troubled by the notion that the title of the statute, 94860, the misdemeanor gun law statute with which Rittenhouse is charged, reads, quote, possession of a dangerous weapon by a person under 18, close quote, but that the application of the exception, referencing statute 29304, completely excludes anyone who happens to be under 18 years of age, but over 16 years of age, such as the then 17-year-old Kyle Rittenhouse. In Judge Schroeder's view, the exception that effectively excludes everyone who's 17 years of age appears to swallow the rule apparently intended to apply to everyone under 18 years of age, if you go by the title of the statute. This apparent irrationality suggests that there must be some hidden intent behind these paired statutes that would allow them to apply to a 17-year-old. And frankly, this seems to me an unconvincing view of the matter, because in fact, the exception does not entirely swallow the rule. A 17-year-old can still be found in violation of Statute 948.60, the misdemeanor gun law charge, because a person under 18 years of age, by violating some other portion of the statute without falling into the exception. For example, had 17-year-old Rittenhouse been in possession of a short-barreled rifle, a rifle with a barrel of less than 16 inches, he would have been in violation of 94860 despite his age of 17 years. The rule would have remained unswallowed despite the exception of 29304. Similarly, had 17-year-old Rittenhouse been engaged in hunting and not in compliance with Section 29304 or 29593, he would have been in violation of the misdemeanor gun law 94860, despite his age of 17 years old. Again, the rule remains unswallowed despite the exception of 29304 under that scenario. Now, Judge Schroeder would counter my own view here by arguing that the real rule, the legislative intent rule, the unwritten rule suggested by the title of the statute, is a generalized intent by the legislature to prohibit persons under 18 years of age from walking around in public with deadly weapons simply as a matter of public policy, and that the defense reading of the exclusion leaves that rule, that implicit rule, swallowed in the context of 17-year-olds. And this cannot have been the legislature's intent. Certainly, that's the argument of the prosecution here. The problem with this view is that this supposed public policy rule is never explicitly stated in Statute 948.60. So claiming this unstated public policy rule requires discerning the ambiguous legislative intent of a legislative body that no longer exists. The current legislature is different than the legislature that passed this statute. So I'm going to share with you here not in this video, but if you go to the text version of today's content, I'll share with you the exchange between defense counsel Chirafisi and Judge Schroeder on this argument as presented at the October 5th, 2021 evidentiary hearing. Now, for what it's worth, Assistant District Attorney Binger, the lead prosecutor on this case, himself appears to largely concede that 29304 does not apply to Rittenhouse for the reasons stated by the defense. By its own plain English reading, 29304 does not apply to 17-year-olds, and one cannot be found to be in non-compliance with a statute that doesn't apply to you in the first place. He does, however, hedge his bets a little bit by arguing that 29304 was intended to apply only to hunting activities, and that Rittenhouse was not hunting, so Rittenhouse shouldn't qualify for the exception of 29304, the exception being that he's 17, not 16 or younger, at all. But this is not an entirely coherent argument. As for the second hunting-related statute, 29593, non-compliance with which could make Rittenhouse subject to the misdemeanor conviction under 94860, the defense argues that 29593 applies only to hunting activities, that Rittenhouse was clearly not engaged in hunting activities, and therefore 29593 does not apply to Rittenhouse any more than does 29304. In short, once again, the defense argues one cannot be found to be in non-compliance with a statute that doesn't apply to you in the first place. And this is where Assistant DA Binger focuses his own argument that Rittenhouse is liable for the misdemeanor gun charge under 94860, precisely on the grounds that Rittenhouse did fail to comply with 29503. Now, more specifically, whereas the defense argued that Rittenhouse cannot be in non-compliance with 29503 because it applies to hunting and he was clearly not engaged in hunting, Assistant DA Binger argues that Rittenhouse was by definition not in compliance with 29503 precisely because he was not engaged in hunting. Binger concedes that Rittenhouse could never be found not in compliance with the previous hunting statute, 29304, because it applies only to people under the age of 17, and Rittenhouse was 17. As a 17-year-old, it was simply impossible for him to be in compliance with 29304, and one cannot be expected to do the impossible. This second hunting statute, however, 29593, has no particular age restriction relevant to the facts of this case, and so in theory, Rittenhouse could have met the conditions of this hunting statute, for example, by obtaining a hunting certificate or license. And because Rittenhouse could have met, but did not meet, the conditions of 29593, he was effectively not in compliance with that statute, and that triggers liability for the Class A misdemeanor gun charge under 948.10. Assistant DA Binger then argues that if the court declines to adopt this interpretation, then the exception would indeed have swallowed the rule. Clearly, this is an effort by him to play into Judge Schroeder's own stated concerns earlier in this discussion. But as I've already noted, that's not really true. There are still ways for a 17-year-old to be in violation of the Class A misdemeanor gun law under 948.10. So, for those of you who have access to the text version of this content, I'll also embed the video of Assistant DA Binger's arguments on this point in the body of that text content. Now, ultimately, Judge Schroeder declined to grant the defense motion to dismiss this misdemeanor gun charge, not on the actual legal merits of the argument, but simply because he wanted more time to consider those arguments. And he had a couple of concerns. On his own concern about the exception swallowing the rule, Judge Schroeder himself noted that, well, sometimes the legislature deliberately creates laws with this intent, however irrational it may seem to outsiders, as part of the political sausage making of statutory law. Certainly, Judge Schroeder expressed awareness of other demonstrable instances of the legislature having done precisely this intentionally. So if the swallowing of the rule by exception was intentional, there's really no need to dig further into legislative intent. It's right there before us. Judge Schroeder also raised a broader and arguably more compelling basis for granting the defense motion to dismiss the charge, and that is on the grounds of vagueness. Now, there's a fundamental doctrine of U.S. constitutional law based in the due process provisions of the Fifth Amendment and incorporated or applied to the states through the 14th Amendment. And it states that a law is unconstitutional and invalid if a normal person reading it would be unable to understand precisely what conduct was being deemed unlawful. Such a law is deemed unconstitutionally vague and without effect. In the October 5th pretrial hearing arguments on this issue of the gun charge under Statute 948.60, Judge Schroeder said, quote, "I'm going to deny the defense motion," that's the defense motion to dismiss this gun charge, "for now. But that's no guarantee that I won't re-examine this. I just don't feel comfortable. It's a penal statute. And to hold people accountable for laws that, well, the basic rule, and there's plenty of interpretation on it, but the basic concept of the rule is that it has to be clear to ordinary people. And if you've got, judges spending hours here and hours more at an appellate level trying to figure out exactly what the statute says, I mean, how does that serve the people? So I'm going to deny the defense motion to dismiss the misdemeanor gun charge under Statute 948.60, subject to reconsideration without motion, meaning without requiring the defense to object again to this charge. I want to give more study to this, and believe me, it's not because I haven't looked at it extensively at this point already. Close quote. So this commentary suggests to me that there is a strong argument that Judge Schroeder will dismiss this charge simply on the basis of unconstitutional vagueness without ever having to get to the legal merits of the argument on this charge in the first place. But should he have to get to the legal arguments, it's my own professional opinion that a plain English reading of 94860 excludes the application to Kyle Rittenhouse on the legal merits. Okay, folks, that's all I have for you for the first part of this analysis, which focused on, is this gun charge at all applicable to Kyle Rittenhouse in the first place? In the next part, part 2, the second of 2 parts, I'll try to link that here in this video, but my, video kung fu is not that great. In part 2, we'll address the second question. And that is that given how petty this mere misdemeanor charge seems to be, why is the prosecution pursuing this so aggressively? Just to have some kind of safety charge because they're not confident in the 5 very serious life imprisonment possible felony charges brought against Kyle Rittenhouse? Or do they have some more sinister motive? Is this a backdoor attack on Rittenhouse's core defense of self-defense in its entirety? So we'll address that in part 2. Until next time, as always, remember, if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.